Hi, Daphne. Nice to see you.
Hi, Michelle. Nice to see you as well.
As I was saying this morning, I absolutely love your background. It looks like something that it just fits with my aesthetic.
Thank you.
Hey, John. Oh, look, Jonathan. We all have the white with green backgrounds. Look at you.
How are you doing, Michelle?
I'm great, Jonathan. How are you today?
Good. What I haven't asked you what your kids did for Halloween. Did they go out?
Wow, we were extremely lucky. My little brother got married in Mexico. So we were in Mexico for Halloween.
Oh
Oh
my
wow.
God. So you
Wow.
Day of Dia del Muerte, is that what it's called down there?
Yes. Now, the day
On
of the
November 1st?
is the first. We were there for the 31st. We flew out the morning of the first, so we missed it, unfortunately.
Oh,
They
okay.
were very sweet, and they had all the kids in the kids club got together and they made a little line and they did a scavenger hunt throughout the hotel and the ground.
Oh,
So they
that's fun.
and they had a bonfire and they roasted marshmallows. And then they did this whole tour of the resort, and every stop they went to, there was a bunch of candy for them. So actually,
Oh,
have a lot of Mexican candy that you can't see, but I have a little pot right here, and every day I try something new.
that's awesome. Well,
Yeah,
that sounds like they had fun. That's great.
it was awesome. What about your kids? You got four as well.
I do, yeah. And actually, for the first time in a couple of years, they all went out trick-or-treating this year. My younger daughter did not dress up. She just went in her track pants and sweater. And my older daughter dressed up like a witch. And my stepson was a Spider-Man. And my stepdaughter, she had so many costumes. I'm not actually sure which one she wore on Halloween, but she went to like two or three Halloween parties, I think three, and then she wore a costume to school, and then she wore a different costume when she trick or treating, and I can't keep them all straight in my head.
Sounds like my youngest. She's four. And for Christmas, she already found the picture. She wants me to make a little dress up station in her room with, like, the hanger with all of the princess
Oh
dresses
my God,
and the
so
mirror that
cute.
looks like Snow White. So and we even bought her, which is so silly, those little baby dress appeals. They're only like, half an inch high, but they look like Cinderella slippers or, you know,
That's
whatever.
adorable.
Yeah.
Yeah. Yeah, my younger daughter definitely went through a massive princess stage. And that probably ended when she was 5 or 6, but she would wear like full on ball gowns to school every day and was always the best dressed kid at school.
That sounds like what mine is gearing up to. So I was actually in the States this weekend, and I was in Target, and basically, I'm ashamed to admit this, but what I did is I FaceTimed her and I went up and down the aisles, and she was shopping as I was walking up and down the aisles, and she'd say, "Oh, I want this for Christmas, and I want this for Christmas." And I said, "Okay, baby, I'll put it on your list." Really, I was putting it in my shopping cart so that I don't have to worry about it later. It was all in. So my Christmas tree is up, and all the presents under there are all for her right now.
Oh, that's fun.
Christmas
It's so great
tree
when they're
is
young and
up.
enthusiastic about it.
Yes. So, Jean, I don't know if you know this about me. I'm having surgery next Friday, and I'm going to be out of commission for 6 weeks. So, Christmas had to happen before my surgery because, as you know,
Yes.
if mom doesn't do it, it doesn't get done.
Yeah, I understand. I understand.
All right, team. I guess we probably should get started, even though it's such a joy chatting with you both always.
Yeah, sounds good. Thank you so much, Michelle. So I'd like to welcome everyone and thank you for joining us for this episode of Family Law Now Live. This virtual event is Risk Factors in Family Violence. My name is Daphne Brooks, and I'm the marketing director at Russell Alexander Collaborative Family Lawyers. And joined with me today, we have Michelle Mulchin, Jonathan Painter, and Jean C. Coleman, who will be our panelists leading this talk. So I will get started with just some brief introductions and let you know what's on the agenda before I pass things over to our panel. So just a reminder, you will notice that the chat box has been disabled. That is just to ensure that your identity remains anonymous. However, if you have any questions in our for our panel, we do encourage you to use the Q&A feature. For today's presentation on risk factors in family violence, our panelists will be discussing the following topics: importance of understanding risk factors in family law, the definition of scope of domestic or family violence, key risk factors for domestic or family violence, the impact of domestic violence on children and risk factors for exposure, identifying and assessing risk in the legal practice, and resources and support systems. We will also have a Q&A portion at the end of the session. So feel free to, again, put your questions in the Q&A and we'll answer them as we go through. We will be providing links to helpful resources mentioned throughout the event as well, so you can keep an eye out for the show notes. And now it is my pleasure to introduce the panel for today. So starting off with Gene C. Coleman, he is a seasoned family law lawyer with over 45 years of experience. He's played a pivotal role in shaping the Canadian family law landscape. He's a founding member of the Canadian Journal of Family Law, Canadian Equal Parenting Council, and Lawyers for Shared Parenting. Gene has contributed to drafting 2 equal parenting bills and has authored numerous publications on family law. A sought-after speaker, Gene has presented on family violence at international conferences in 2022 and 2023. His passion for family law reform stems from his deep understanding of the emotional and traumatic impacts on families, including the devastating loss of a client to domestic violence. As a devoted family man and dedicated advocate for families, Gene brings a unique blend of professional expertise and personal perspective, drawing from his experience as a father of 7 and grandfather of many. Thank you so much for joining us today, Gene. I really look forward to what you have to say on the topic.
Thank you.
We are also joined by Michelle Mulchin. Michelle is the senior managing lawyer at Russell Alexander Collaborative Family Lawyers. She's been practicing family law for over 14 years, specializing in divorce, custody access, property division, and child and spousal support, and family responsibility office enforcement matters. Her focus is on creating comprehensive, creative solutions to family law matters. Michelle excels at helping clients deal with complex financial issues that arise as a result of separation. Thank you, Michelle, for joining us today.
Thanks so much. I feel like a baby compared to Gene. I can't wait to hear his presentation today.
And we are also joined by Jonathan Painter. Jonathan is a registered social worker and psychotherapist who works in the family law system, completing parenting plan assessments, voice of the child reports, family mediation, and collaborative family law in private practice. He also provides psychotherapy such as cognitive behavioral therapy, family therapy, couples counseling, and does this for children and adults. Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as treasurer of the board, and is on the board of Collaborative Practice of Durham Region. Thank you, Jonathan, for joining us today as well. I will now hand things over to our panelists to get started.
Thanks so much, Daphne, for those beautiful introductions. Okay, so why don't we start with a poll? And the reason we like to do these is just to get an idea of how our audience is made up. You know, are you a lawyer? Are you a clerk? Are you a student? Are you, part of the system? Are you a potential person who's going through a separation or divorce? It just really helps us to understand, who our audience is and try to tailor some of our answers to them. And I'm the worst for that, Jean. I often will forget and go into acronyms and, get into the lawyer speak. So it's always a good reminder about who our audience is made up of. All right, let's see the poll results on that. Perfect. Perfect. Okay, so 68% of us are family lawyers. That's wonderful. Welcome, everyone. 11% is lawyers practicing in other areas. We have some mental health professionals, some law clerks, some students, and then a couple of people who are navigating separation and divorce. So welcome, everyone. Thank you so much. So, Jonathan, why don't I hand it over to you to talk a little bit about risk factors in family law?
Yeah, so it's really, really important for anybody who works in family law to understand the risk factors, because many family law files involve family violence. Unfortunately, abuse and violence are very common in our society. The rates have been going down pretty steadily since the 90s, but they're still way too high. And it's consistently the major reason why people in Canada still separate or divorce. The leading cause actually is family violence or abuse. So if you're working in this field at all, you're going to come across this issue at some point. And if you don't know how to screen for it or understand the risk factors, you should not be practicing in this field. It doesn't matter if you're a social worker or a psychologist or a lawyer or family mediator, arbitrator, whatever. You will not be able to serve your clients appropriately and protect their interests and well-being and safety if you don't understand what are the risk factors in family violence. And it's kind of even to the point now where there was a recent law that came into effect, Kira's law. I think it came into effect in the spring last year sometime. I can't remember the exact timeline, but that law related to a family that experienced a lot of violence, and the father ended up killing the daughter, Kira. And when there was an inquiry into what happened, they found that the legal system really didn't know what was going on. Judges weren't trained in family violence. I think the family had a revolving door of many different judges, and nobody really knew what was going on. And some of the orders that they made did not make sense, and one of them kind of ended basically in Kira dying. Not directly, but. So it's recognized throughout the legal system, throughout the government, that screening for family violence is very, very important. And keep in mind too that no matter what profession you're a part of, you probably have a code of ethics, or I'm not sure what it's called in the legal system. I think it might be like code of conduct or something. But there are rules that we as professionals have to live by. And for social work, which is my professional designation, and mediation, I'm an accredited family mediator as well. It's required by your profession. If you're going to work with families, you have to know how to screen for family violence. So it is, in my opinion, one of the most critical pieces of information that is needed in training family law professionals, no matter what background you have, right? So I would encourage everybody who is on the call, if you haven't had training in it, make sure you run out and get some. There's lots of good training available out there, and it's really, really important to understand the risk factors so that you can meet your clients' needs, keep them safe, and not cause more harm than good. Michelle or Jean, you have anything to add to that?
Yeah, I'll jump in if it's okay. Thank you
Yeah.
for that, Jonathan. One of the handouts that will be coming to you all afterwards is an excerpt from the American Bar Association magazine Family Advocate, which just came out a few weeks ago. And it's from an article by Alan M. Bailey, who is a family law lawyer in Alaska. And he gives us an Appendix A and an Appendix B, and that's what you'll be receiving. The Appendix A, he describes the characteristics of coercive controlling abuse and gives 12 characteristics that have sub-characteristics. It's a good read. And his Appendix B is a domestic violence screening tool. and he has a whole list of items that you should be going through with your clients at a first interview, and as I'll be telling you later if we have time, and even subsequent interviews to check if you get the same responses. There are various other screening tools available, and I think, Jonathan, you're going to be mentioning some of those later. So, and there's lots on the internet as well, screening tools that you can get. You must take family violence seriously.
Yeah, and one thing I didn't mention, Jean, is that the rates of family violence among the family law clients is much higher than in the general population. And so you're much more likely to come across it in family law than you would, as a salesperson for Rogers or, some other kind of job. So it is, all that much more important that we understand it. And I really appreciate Eugene bringing up the issue of coercive control, because it's not only important for us to understand sort of generalities about family violence, but also know how to categorize it. Is it coercive control? Is it situational violence? And or is a client or the other party, are they violent in different contexts, not just in the family? Do they go to the bar and start fights? Do they have road rage incidents? All those kinds of things. We need to know not just whether there's family violence, but we need to know kind of how to categorize it so that we can respond to our clients' needs more effectively.
There is a big difference between a one-off, out of character, violent act or violent exchange between a couple and they separate, versus a relationship characterized by coercive control and those various factors that you have mentioned, Jonathan.
Mm-hmm. Yeah, very well said. Agreed.
Thanks so much, guys. So Jean, why don't we turn it over to you to talk about the definition of scope of domestic or family violence?
Thank you. There, I think, is it working now?
Yeah.
There we go. Okay. Had to click all the right buttons here. There we go. All righty. Just have a very few number of slides. We have a lot to cover, and I have about 10 minutes allocated, maybe one extra minute or two that Jonathan left over. Most provinces have amended their legislation to align with the Divorce Act amendment. So while I will refer to the Divorce Act here, know that Ontario has virtually the same provisions, as do many of the other provinces, but not all. In section 2 sub 1, we have a definition of family violence. Note that it's towards any other family members, not just to the spouse, it's to anyone in the family. And family can be interpreted, in my view, very broadly. And John and I were talking about a pattern of coercive and controlling behavior. Well, lo and behold, it's in the definition section. Section 2.1 goes on to describe, or maybe it's 2 sub 1, excuse me. It goes on to describe what family violence may consist of, and there on the shared screen is part of that section. And it's not just spouse A hitting spouse B or threatening to hit spouse B. It's much wider than that. And the previous slide ended with the words "and includes," and then here you have the list on this slide. So just know that it's very, very wide definition, as it should be. If a child is exposed to family violence, whether direct or indirect, it can have long-term effects. My authority for that is the case of KMN versus SZM 2024 98 RFL 8th 275 British Columbia Court of Appeal at paragraph 73 and 79. I realize I should probably prepare with the case, a little page with the cases I'm referring to, and I'll send that to the coordinators of this webinar. Now, some takeaways from the statutory definition in the case law, in my view, are as follows. The violence does not have to equate to a criminal offense. Any behavior that a family member might perceive to be violent or threatening could constitute family violence. Coercive and controlling behavior of any kind will constitute family violence. Sexual abuse by one partner against the other, of course, family violence. If you stalk your spouse either before or after separation, it's family violence. And I say that stalking can include online stalking. Think twice before canceling credit cards or otherwise limiting spending. It could very well be family violence. When I went to law school in my early years of practice, it was almost de rigueur. Cancel her credit cards. Be careful. Be careful. You smash a door or break a glass, even where the other spouse is not present, nowhere near, it's likely family violence. Say you threaten to do any of these bad behaviors and don't actually do them, it's family violence. Bad behavior in the widest sense of the term can now constitute family violence. Turning now to section 16 sub 3 of the Divorce Act expands the scope of how we consider family violence. What is germane for our discussion today is subsections 16(3)J and K. Notice the correct focus on the child here. You have J and K up on the screen. Just let you have, I hate people that read their slides. I'll give you a moment, read the slide, see the section, note what I bolded. So it's a wide definition. And notice in J sub I, what about the perpetrator's willingness to care for the child? And later we're going to find another factor, his willingness to seek treatment and be serious about it. In 16 sub 4, we get further direction, how to interpret that previous subparagraph J. And like John and I were mentioning earlier, the nature, serious frequency of the family violence. A one-off doesn't necessarily have drastic consequences. It must have consequences, because if it's evidence of an anger management problem, that has to be dealt with. We don't want to expose children or ex-spouses to suffer this sort of behavior. And notice again here, a pattern of coercive controlling behavior. Again, it's mentioned. And notice risk of harm. And the section goes on. In sub E, we're talking about the safety of any family member here. And now here, what I was just mentioning a moment, sub G. This sub G is very important, very important. Has the perpetrator had a wake-up call? Is he or she going to take responsibility for their negative behaviors and seek treatment, learn to mend their ways, take anger management if need be, and improve their behavior and remove the risk factors? You, as counsel, my friends, have to tell a perpetrator that that's what he or she needs to do to preserve the relationship with his or her child. And notice H, any other relevant factor. So who knows? They're wide-ranging factors, as they should be. Indeed, the courts have interpreted these provisions liberally. And now, I mentioned again sub G. Sub G is, in my view, a safety valve. If your client is going to be caught by the family violence expanded definition, if your client has indeed behaved badly within the meaning of the Divorce Act, then you simply must persuade your client to take substantial, persuasive, credible, and all-encompassing steps to address the issue of his or her alleged family violence. In my view, if the abuser can clearly demonstrate that he or she has changed his or her ways, then he or she has gathered education, insight, that he or she no longer poses any risk of family violence to anyone, then perhaps that now that former abuser will be able to salvage a meaningful relationship with the children. I will tell one brief story. How much more time do I have? Do I have 5 minutes? Or am I finished?
You've got about 5 minutes there, Gene.
Okay, good. I think I can do it. We had a client in our firm some years ago who got into a physical fight with his it was common law spouse. He bit her cheek open and she had to have a number of stitches. Like, oh my goodness. From what I heard, it was out of character for him, but the abuse was very serious. And you can be sure that myself and the other members of my firm took this really seriously. We helped him form a treatment program and therapy program, and both for the present and going forward. And we presented the entire program, the progress we made so far, what the goals were to the mom. And ultimately, we were able to restore his relationship with the younger child. The older child, who was in his early teens, was having none of it. He had witnessed this. But there were parts of the program to try and deal with that to assure the older child, but the older child wouldn't. But at least the younger child, we were help him to pursue his relationship on a healthy basis. On the flip side, if you represent the victim of family violence and the offending spouse has not taken any steps to ameliorate his or her behaviors, then point to this subsection and argue that the court must ascribe some meaning to it. And in the absence of evidence under sub G, the children are still at risk. Does parental alienation, to switch gears now a little bit, constitute family violence? I say that it does. It often amounts to coercive control. It is often accompanied by rather significant gatekeeping. It often entails the alienator parent cruelly coercing the target parent, let alone the children. There's a recent case by Justice Jennifer Dodlin, who we all know from the Family Dispute Resolution Institute of Ontario. So a fairly recent appointment. The case is SC versus MS 2024 ONCJ 371, paragraph 44 as follows. Denigrating your spouse in front of the children fits within the definition of family violence, and she cites two other cases. Paragraph 45, regularly engaging in behavior that has the effect of undermining the other parent's authority or influence and alienating the child from that parent is family violence, and she cites three other cases. In closing, for this part of our presentation, I'll let you know that I have given the link for a recent National Post article, came out a few days ago, on male victims of abuse. Family violence travels always with all genders. And I've also prepared a few sheets with recent case law references. Oh, so that will include the cases that I've mentioned here. Recent case law references, many cases, of course, that I have not mentioned here this afternoon. And I've also prepared a list of social science references. Not every social science article written on the topic, certainly not, but some of the more recent ones. And I provided links to the cases and links to the social science articles, and we'll be happy to share that with you following the webinar today. And now I think it's over to Jonathan for key risk factors for domestic or family violence.
Okay, so there's basically three ways to find out if there is violence in your clients' lives. The first is just to do an interview and talk to them. That can be useful because some important details could come out. But what I think is a better approach is to use what's called a guided questionnaire. So there are several screening tools that have been developed specifically for family law. Some of them specific to mediation, some of them not. But they can be used by any family law practitioner, no matter what process that they're using. So they're good for court, they're good for mediation, they're good for arbitration. So some examples of those are the MASIC, which I will not remember what it exactly stands for, but something about mediation assessment of risk. There's also a homegrown one from the Barbara Schliffer Clinic called the RIA, which is really good. And I like that one because it also takes into account cultural issues and language issues, those kinds of things. There's one very specific to violence itself called the DOVE, which is also a really useful tool. So those are screening tools, and the way they work is they're supposed to guide your questions with your clients. It's not a form that you hand to the clients and say, here, fill this out and check all the boxes and hand it back to me. These screening tools have to be used in a conversational way so that you are bringing this information out in a conversation, and that the client isn't getting the form for the MASIC or the RA or whatever you're using. So those are widely used, and in fact, I believe family mediators are required to use them if they work or if they're accredited through the OAFM, the Ontario Association for Family Mediation. And then there's other kinds of assessments called actuarial assessments. And most people know about actuarial assessments. If you know about them at all, most people don't know about them. But if you do know about them, most people know about them through insurance, because actuaries are insurance people who are designed to look at risk. Now, they don't look at family violence risk, but some people way smarter than me have come up with tools that will actually give you a percentage likelihood that a particular kind of behavior is going to happen. So these risk assessment tools, they actually use statistical risk factors. So they have huge data sets. They look at thousands of families and individuals and try to figure out what are the common factors, what are the most prominent risk factors for whatever kind of violence. And there's different ones to use depending on what kind of violence you're talking about. So for example, another locally homegrown one is called the ODERA, the Ontario Domestic Assault Risk Assessment. And that is specific to violence against your partner. And then there's a VRAG, which is the Violence Risk Assessment Guide, I think. And that one just talks about general violence. So it's not specific to family violence. And you'll notice that the risk factors in those two risk tools that I just mentioned are different. There's quite a bit of overlap in them, but generally they look at different things because they're trying to predict different kinds of behaviors. So the risk factors will look a little bit different. So the number one risk factor across the board, no matter what kind of violence it is drug or alcohol use. And that's a really, really important one for us as family law professionals to know and to screen our clients for substance use, because what happens is we have what are called executive functions in our brain. That's the prefrontal cortex behind our forehead that gives us those. And when you have even a small amount of drugs or alcohol in your system, you lose the ability to use those executive functions. And those executive functions are the thing that limit your behavior and keep your behavior appropriate. So if you're angry, say you're at work and your boss is rude to you, those executive functions prevent you from kind of punching your boss and getting violent with them, and inhibits all kinds of negative behavior. But when you've been drinking or using drugs, those inhibitions go out the door, and then all bets are off. So if a client has a serious drinking problem or a drug problem, it doesn't really matter what kind of drug. You know, I know there's a lot of stereotypes, for example, about cannabis use, and that all cannabis users are, you know, laid back stoners who are chilling on the beach, but cannabis use is also a risk factor. So any kind of drug, heroin, alcohol, cannabis, cocaine, ecstasy, speed, all these things can increase the risk of violence. Other factors might include mental health. And I want to be very clear, just because you have a mental health condition doesn't mean you're at higher risk of violence, but there is a lot more mental illnesses among people who are violent towards their partner. Some very clear risk factors would be things like if a person has ever been sanctioned by the police and they violated those sanctions. So they were given a bail conditions or recognizance order or something like that, and they violated them. That's a real red flag. If you see that in your client or in the other party, your hackle should be raised, alarm bells should be going off. That's a very high risk situation. That person has been sanctioned by the law and they don't care. Those are the people you really want to watch out for, because they're much more likely to be, you know, either severely injuring their victims or even murdering their victims. So generally, stress is another indicator. So people living in poverty have more stress and are more likely to engage in violent behavior. It doesn't mean that it's exclusive to families that are poor. It happens in all socioeconomic strata, but it is more likely the more stress that you have in your life. If there's a history of violence, that's a big indicator. So people who are violent in lots of different contexts are much more likely to be violent towards their partners and their children. And so that, again, should be another red flag that this is potentially a very high conflict, high risk case. If that person has been in trouble at school, if they have past criminal convictions for things like road rage or bar fights or fighting with their brother and sister or fighting with their neighbors. If you see that kind of behavior, make sure that you're paying attention and focusing more on preventing risk in those kinds of situations. There's also risk factors that are family-based. So, for example, the ODERA identifies children in the home as a risk factor. So the more children in the home, the higher the risk. And if there are stepchildren in the home, that also increases the risk. If the victim has been drinking or using drugs, that also increases the risk of violence. So there's a variety of ways of kind of teasing out those factors. The screening tools like the MASIC and the DOVE, they don't statistically tell you what's the likelihood of this behavior happening again. They just say, hey, this one's something you got to pay attention to. Assessment tools like the ODERA will actually give you a percentage risk. This person is 63% likely to commit another offense, or 83 or 20%, you know, so it'll give you an actual percentage risk. And one of the reasons they did that is because when they were developing the ODERA, and they were collecting all the data, which would tell them what risk factors to include. When they started showing professionals like judges and lawyers and social workers these assessment tools, they realized that they used to have a category, it would be high, medium, or low risk. And what they found was that people's idea of what high means, what medium means, what low means differs. There's no inter-rater reliability on that topic. So that's why they include an actual percentage chance instead of using high, medium, or low risk, like some risk assessment tools do. If you're going to get into this work, I highly recommend you take a course on screening for domestic violence. so incredibly important. It is a requirement if you want to become a family mediator. It's not if you want to be, a collaborative family professional or a lawyer, but I think it really should be, because it is such a vital piece of the work. And as Jean kind of alluded to, sometimes people's lives are on the line. And if you don't take this stuff seriously, if you don't pay attention to it, if you're not prepared to, send your client for safety, creating a safety plan, or to resources that can help them escape a really violent and abusive situation, then you're not going to be effectively meeting the needs of your client, and you won't really be able to work effectively and meet your client's needs. Unfortunately, we all know stories of, really severe tragedies where people have died because the risk wasn't taken seriously, or it was ignored or not understood. The other thing that is important to note is, as Jean mentioned, the law really focuses on the best interests of the child in the context of family violence. And we know from oodles and oodles of research that has been done over the last few decades that family violence is really, really bad for kids. It counts as what's called an ACE, an adverse childhood experience. And adverse childhood experiences are things like abuse, neglect, witnessing violence, sexual abuse, that aren't just negative experiences for children. They actually change the way they develop, and their nervous system and their whole body develop in a different way when they've had a bunch of those experiences versus kids who haven't. Kids, for example, who have 4 or more adverse childhood experiences before the age of 18 are 3,000% more likely to attempt suicide as a young adult or a youth when compared with children who haven't experienced any adverse childhood experiences. So we know that it's a very, very high risk of, long-term harm to the children, both mentally, so they're much more likely to develop depression, anxiety, suicidal behavior, addictions, all these kinds of things, but also their body. So they're much, kids who experience family violence are much more likely to develop diabetes, heart disease, cancer, emphysema, COPD, all these medical conditions that we think, well, they're probably not related to your childhood experiences, but they actually are directly related. And it's not just genetics, it's also these experiences that set up the body for failure later in life. And there's this concept in sort of psychology and health called allopathic load. And it's basically the amount of stress and negativity that your mind and your body can take in your lifetime. And the higher the stress, the lower your lifetime. There's a direct correlation between the number of stressful experiences that you have in your life and early death. So we want to prevent this and protect kids from experiencing this, because we know it causes them long-term harm. The other thing it does is it perpetuates the problem. So if you have had a family that's violent growing up, you're much more likely to either end up in a violent relationship as an adult or be violent in a relationship as an adult. So across the board, it's really, really important to make sure that children are protected from this kind of thing. And as Jean said, there are treatments available for people who engage in violence. There's lots of good programs out there. And a lot of them are child focused. So there's one program offered in our area, at least by the John Howard Society, and I've seen it in other areas also offered by the John Howard Society, but it's not offered by John Howard in every single jurisdiction, but it's available out there everywhere in Ontario, called Caring Dads. And that program is specifically to help fathers understand the impact of violence on their children and how to prevent it, so that they're not setting their children up for failure later in life. I think that we're really just at the beginning stages of really the legal system recognizing and understanding and taking this problem seriously. I think we've got a really long way to go. Domestic violence cases are still very, very common in family court and in family mediation and collaborative family law. And it's a really big societal issue. And I know there's lots of people, very, very good people out there working to prevent this and protect victims of it. But it is a major issue, and I can't overemphasize how important it is for family lawyers, social workers, financial experts, anyone working in family law, judges, to understand and be able to identify those risks. And not everybody has the same level of knowledge on this. So if you end up getting a case and you feel like the violence is more severe than you're used to handling, or you don't really understand it, then get help. Reach out for supervision if you're a mental health professional, or get training, or if get a colleague on side to help you with the case and give you advice, or maybe it's too much for your level of skill and experience. So it might be a good idea to kind of pass it on to a professional who's more experienced. And I would guess the same is true with the family lawyers. If you don't have a lot of experience in this issue and you are getting a case that it has a lot of severe violence, then make sure you get help or pass it on to someone who knows, has more experience working in that field. Yeah, so that's kind of I guess a brief snapshot of both how to screen and the effects of family violence on children. I don't know if Jean or Michelle, you had anything to add to what I said there?
Thanks so much. Just before we get to that, do you mind if we run the next poll just while we're chatting? So
100%. Yeah, go
whose
ahead.
responsibility is it to screen for family violence? So while we're everyone is answering that, Jean, did you have any comments for Jonathan?
Jonathan is a veritable font of information on this topic, and I learned a lot. I thought I knew a lot about family violence, but I guess we all have something to learn. And we have to, once again, my friends, take family violence totally seriously. Don't underestimate it. Don't say, oh, a terrible consequence will never happen in my practice. It could.
Absolutely. Thank you, Jean. Okay, let's see the results of that poll. All of the above. Jonathan, do you want to speak to the answer on this?
Yeah, I feel like I might have set this poll up poorly, because I did say several times that it was everybody's responsibility to screen for this stuff. So we probably should have set the poll up before I said all that. But yeah, no, it is everybody's responsibility. And the real problems often come up when people assume someone else is going to look after it, right? When you look at the most tragic stories where children have died, or mothers or fathers have died because of violence, almost every single time there was a professional or multiple professionals who thought, well, someone else is going to look after it, right? I can't remember the poor boy's name, but there a couple decades ago, a young boy died after being placed in I think aunt or uncle or cousin's home by the Children's Aid Society. And in that case, the teachers, the doctors, the social workers, the therapists, they all noticed things that were very concerning, but they thought someone else was looking after it, and they never communicated with each other about this. And the child died as a result of the abuse that he faced. And the same thing was true for Kira. Somebody thought someone else was going to look after this, and the Children's Aid Society, the family court, the lawyers, the social workers, all those people were not communicating well enough to prevent this. So don't assume someone else is going to look after it. Take responsibility for it and do the screening yourself. It doesn't necessarily mean that you're going to be the one to solve all their problems. They're probably going to need more help. Maybe they need to be referred to a shelter or a therapist, or a doctor or lots of services out there to help them. So you can only do what is in your wheelhouse to do, right? If you're a lawyer, you're not going to provide therapy. And if you're a therapist, you're not going to provide family law advice. But make sure that if someone is experiencing a very high level of violence in their family, that they need help. They need more eyes on the situation. They need more support. I mean, we're a very social animal. When we're feeling down or stressed or upset, we benefit from being around other people and getting support. So don't hesitate to reach out, both for yourself and for your client.
I will add one point. I
Yeah.
thought of it while you were speaking, Jonathan, and it went out of my mind. Now I got it. To the lawyers, the relocation provisions of the Divorce Act and our Ontario Children's Law Reform Act set out requirements that the moving parent has to take within certain time, the contents of the notice that has to be given, the amount of time that the remaining behind parent has to reply, under what circumstances the relocating parent can move, etc. And we'll get into details. But what I would like to point out there, perhaps less well known in those sections, that if there is family violence, the relocating parent can move. Now, if I were advising the relocating parent, I would only do it by way of ex parte motion. Motion without notice. Shouldn't use Latin these days. Motion without notice. And you can bring a motion without notice when the sequelae, the consequences of giving notice, will be potentially quite severe and drastic. If you meet that test, and the family violence is of a nature where your client has to escape on his or her own and or with the children, then consider that. Don't think, oh no, I got to give notice, got to 30 days, 60 days, whatever the notice period is. I can't do it. We got to give no, you can do it without notice if the situation is serious enough, and don't hesitate to use that. But my advice is, don't act unilaterally. There's lots of case law going back to Justice Vogelstein's 1991 case. Name escapes me at the moment, but you normally have to give notice. But in severe situations, you can not give the notice. Poll number 3 now.
Yeah, let's do it. That sounds great. All right. So what are signs you can look for to determine if there's a domestic violence taking place? This is really interesting because if you read some of these screening tools, you'll be able to see it's quite interesting how in-depth they really are. We'll give people just a minute or two to answer that before we go in. Jonathan, just going back to your comments, allostatic load. It's actually something you taught me about a month ago when we did our family law summit, and I've been looking into it. And what an interesting concept. I mean, it's really new, but the science behind it is so fantastic and so interesting to look at, and we see it in our clients all the time. You can see even how clients present themselves, their energy levels, their ability to speak and to be able to adequately talk about what's going on in their lives are often impacted by the amount of stress that they're under. So thank you so much for that. If you have time, participants, allostatic load, ALOSTATIC, really interesting research out there. All right.
If anyone's interested in the topic of adverse childhood experiences, I did a workshop last week on that very topic, and it is available online for purchase if anybody's interested. But I think that's another whole topic. I mean, I could do a whole day. I mean, that presentation I did last week was 3 hours, but it's an important concept when thinking about family violence, because it does very negatively affect children, and we know right down to the detail of their DNA, why and how it affects them. So it's a fascinating topic, in my opinion.
Thanks so much, Jonathan. Okay, all of the above, 97%. Absolutely. Sorry, I don't want
Good.
to. Go ahead, Gene. You can.
That was the right answer.
We're doing something right in our session. All right, Gene, why don't you take it away to the next topic?
Identifying and assessing risk in legal practice. I'm going to tell two stories that are very dear to my heart, and I will try not to get overly emotional and cry. You have to screen for family violence. Boy, Jonathan has made that really clear. And let me tell you guys a story. This happened in the 1990s, the first half of the 1990s. And I had a client. She was a Russian lady, went to Israel. The family went to Israel, and from Israel came to Canada, starting off in Russia. 2 children. And she came in with her mother, the grandmother of the children. Normal family law situation, normal issues, property and support, spousal support, child support. It wasn't anything crazy, seemingly. And based on the tools that we had back then, I screened for family violence. In fact, I screened twice for family violence. And I remember the day they're walking out, and Grandma comes back to me. Mr. Coleman, don't let anything happen to my daughter, please. And I said, Mrs. Zed, I'm not saying her name here, though it's reported in the case law. We had to litigate with the husband's brother afterwards. I said, is there something you or your daughter didn't tell me in the last 2 interviews? Is the husband violent? Has he made any threats? No, but don't let anything happen. And I asked it the same question 10 different ways. As it turns out, the husband was waiting for her in our parking lot at 4580 Dufferin Street, where I practiced at the time. He followed her back to their apartment. They weren't separated yet. It turns out, we learned later, that he had a delusion that my associate lawyer, junior lawyer, who was going to be lead counsel, who was lead counsel and taking a large part in the case, was having an affair with her. It was just crazy. He stabbed her to death in the washroom, door open, using 2 knives from the kitchen, with the children watching. Mark, my junior, and I, of course, we went to the funeral. We went to the Shiva. And Mark, who had a promising career ahead of him in family law, quit family law because of that. But of course, the worst tragedy was these children lost their mother. And the mother's mother, the grandmother, lost her daughter. It was life-changing for me. Life-changing. You, my friends, lawyers I'm speaking to now, are responsible for the safety of everyone who is involved in our family law system. I'll tell you another story now. Actually, I said 2 stories. I lied. 3 stories. Another second story. This was in the early 80s. I was called in 1979, one of my first trials. I had really serious concerns about my client. I didn't have the knowledge of family violence back then that I have now. But the allegation was, which he denied, of course, the allegation was that he tampered with the brake lines in the car. So she didn't get killed, but the brakes failed. And there's other allegations of violence against him that he denied. But I wasn't having a particularly good feeling going into the trial. I called court services. They didn't call it court services back then, whatever they call it. But I called court service, said, can we please have a police officer in the court the entire time? And I want a police officer accompanying the mom, not my client, the other side client, from her car to the courtroom and from the courtroom to the car. And I want another police officer or court services officer keeping the guy back, and I would try and keep him back and talk to him and debrief and stuff. We have to take these things seriously. Doesn't matter our client, the other client, the judge, anybody. We are officers of the court. This is our responsibility. Story number 3. This is not too long ago. We had a client whose behavior was escalating. We were receiving increasingly irrational and threatening emails from him, implying harm to the mom. And looking back at it now, one of the factors Jonathan talked about so well was, are there drugs and alcohol involved? There was definitely alcohol involved, and we believe there were drugs as well, though we couldn't prove it, but we knew there was alcohol involved because we arranged to have a monitor put on him so he would at least have parenting time, and as long as the monitor didn't give off an alarm. But we thought we had him under control. I, of course, had explained to him about family violence, that he had to be totally frank with us, and we would take steps, and then we got the monitor. That was our idea. But the emails this afternoon were getting worse and worse and worse, and I read it as a threat against the life of the mom. So what was I supposed to do? My client's going in a half an hour to pick up his kid for his regular schedule of parenting time, and I'm really concerned about mom. Should I call the police? Should I call the CAS? So here's what I did. I called mom's lawyer, got her out of a meeting, because I said this was a life emergency. Got her on the phone. She's a judge now, by the way. I got her on the phone and I explained to her what was going on. I read her excerpts from the emails. I said, oh, I'm not waiving solicitor-client privilege, but let me read to you some of the things he's written. I take this seriously, and she did too. I said, please call your client right away. She should not go unaccompanied. Preferably the police should be there if you can arrange it in the next 15, 20 minutes. But we must protect your client. He fired us because then we told him, yes, we were the ones that blew the whistle on him, and he fired us. And though I felt there's more we could have done to help this fellow, but it was his choice. So I take solicitor-client privilege seriously, but I'm telling you, my friends, in my view, this is Gene Coleman's view. I don't speak for the Law Society. I don't speak for anyone else. I'm speaking for me. Called to the bar in 1979, doing family law cases since the second year of law school at Community Legal Education Services in Osgood. Your responsibility for the safety of everyone in the system rests on you. We are officers of the court. We are human beings. We take action. And if that involves breaking solicitor-client privilege, that it involves breaking solicitor-client privilege. I think a life is much more important. Now, when that lawyer summons me to the trial to give evidence, at that point, there was no danger to anybody. I refused to answer every single question. And I told her in advance I was going to refuse to answer because I broke the privilege on that one occasion because it was necessary. And the trial judge agreed with me that I did not have to give over any information. Watch for the danger signals, substance abuse, threats to anyone, whether verbal and or written. Take action and err on the side of safety. I'm sounding like a broken record. Refer your client to mental health services, but when necessary, prudent, take measures to protect everyone's safety. And again, as I mentioned, you'll get that ABA article excerpt, and Jonathan has outlined for you already some of the testing, the screening tools that are available. Take action. Don't leave it to someone else. It's our responsibility. Poll number 4 now, I think.
Thanks so much, Shane. Okay. To mitigate or prevent imminent harm or imminent risk, what steps should a lawyer take? So actually, Jean, I know you and I were talking about this. I don't know if I shared my story, but I had a very similar situation happen. And I did the same thing as you. I called the opposing counsel and I advised them
Good.
what I was able to advise them of. And I remember I was actually at Blue Mountain and I was at the pool. I was on vacation at the time when I got this email from my client. And it didn't matter where I was or what I was doing, dropped everything, called the opposing counsel. And the client did not actually fire me in that instance. He apologized profusely and said it was a error in judgment and that he never intended to act on it. But I think it really showed him and it paved the way for settlement because he knew that there was a line. And if he ever crossed it, we as counsel, both counsel, would not allow that to happen. So I thought that was a really interesting example. Okay, so let's see the poll results. Stop acting for the violent clients, about 33%, 75% call the cops, 75% call the opposing counsel, 62% call Children's Aid, and 65% refer the client to counseling. Jonathan, what do you think? What do you think the answer is?
Well, yeah, I'm going to say something a little controversial here, but it's really important that the violent person not be dropped like a hot potato and not getting any support or services. We know that stress is one of the risk factors for family violence. And if the perpetrators of violence are not getting the support they need, they're more likely to be violent, right? So a lot of people mention that they would stop representing their client, but I would encourage you to keep representing your client and try to steer them in the right direction, right? Try to steer them towards a Caring Dads program or a PAR program or, meeting with a psychologist who specializes in violence prevention or treating violent behavior. There are things we can do both for the victim of the violence and the perpetrator to prevent this from happening in the future. So from my perspective, I do a lot of work in as a neutral in as a family mediator or a collaborative family professional, and it's really important that I pay attention to both the perpetrator of violence and the victim and make sure that both of their needs are met as much as possible. But like if a violent perpetrator is not being represented, they're not going to have someone who's the voice of reason saying, hey, maybe you should take a Caring Dad course. Maybe you should agree to supervision with the children. Maybe there are steps you can take to lower your drinking habits or your drug habits. So I believe very strongly that that perpetrators should also be supported. Obviously, the supports are going to look very different from that of the victim, but it's important we pay attention to both their needs and try to support them and reduce the risk of violence. What do you think, Jean?
Yeah, I agree. Stay with the violent client because hopefully he or she respects you and you can have an influence. If you get fired, as I did, well, you get fired. Calling the cops, of course. Call opposing counsel, of course. Referring the client to counseling. The question talked about imminent harm or imminent risk. So referring to counseling in that situation, not appropriate. Yes, a few days later, of course, but take action to prevent imminent harm imminent risk of harm.
Thanks so much, Jean. Okay, why don't we go into resources and support systems?
We don't have time. That's why. And Jonathan and I have covered it, and we've got a bunch of really good questions. So how
Excellent.
about that, Michelle?
Sure. Yeah, no, that's great. Okay. All right. So let's go into Q&A.
I think too, like Jean, we've created a handout that's going to be sent to people with resources in it as well. And anybody who's listening is welcome to reach out to me and ask about resources if they need extra support.
So not to bog you all down, but I think our resources are well over 100 pages at this point, plus lots and lots. So
it's probably not even it's probably a drop in the bucket of all of the resources that are out there, right?
Absolutely.
And Jonathan, I'm very much looking forward to your list of resources, which I am going to distribute to everyone in my firm and also put in our precedent files.
Yeah.
Great.
I know I said it at the last when we did the summit, but one thing I tell all of my juniors is when you find a good resource, or let's say you look at the screening tools or you do a course and you find something you really like, print it out and put it in a binder. I have a binder right in front of me that I can grab, with one hand and have it ready, because you never know when you're going to get that call.
Old school electronic binder.
We had the
didn't you listen to any of Justice Curtis's seminars pre-COVID on making everything electronic?
Well, we have a resource library that we have for our firm, and it has thousands of documents.
I'm sure.
One of those things that when you get the call, you don't want to be logging into the system and looking for the right, subject and section. You want to have it just right there. All right. So very first question that I think is important. What is the one thing, the one takeaway that family lawyers should do that they can start implementing today?
Educate themselves about family violence.
Thanks, Jean. Yeah, so for me as well, I thought it was look for family violence training in your area, and read some of the screening tools. My personal favorite is the MASIC, but just having read the MASIC, and I look at it once a year just to refamiliarize myself. We do the seminar once a year, so it forces me to look at it once a year. It just reminds you of all of the different questions and the different ways that you can start to see family violence. Jonathan, do you have anything else to add to that?
Yeah, so I think that the OAFM is a really good resource for training on family violence. They offer a 21-hour family violence screening program, and there's lots of different companies and organizations that offer it. I know York University has it, Humber College, Riverdale Mediation. There's I can't name them all. There's dozens of them. So that's a really good resource. I personally absolutely love the AFDC, the Association for Family and Conciliatory Courts. I think the training programs they offer, the conferences they offer are super, super high quality. And when you're going to those conferences, you're often getting the latest research on whatever topic that you're learning about, whether it's family violence or adverse childhood experiences or whatever other issues. So I would strongly recommend that if you're local, if you're Ontario, the local chapter of the ASDC puts on a fantastic conference every year in I think it was just in October, and I found it to be fantastic. And their international conference is really good as well. It comes to Toronto every few years, but I think the next one is in New Orleans. Last year was in Boston. So it's a great opportunity to go and travel to a new city and learn all about family violence. So they often have like the preeminent researchers in this field presenting at those conferences. And I find that the quality of those conferences really high.
Thanks so much, Jonathan. Those are great resources. Okay, how do you deal when your client is a potential victim of family violence and is willing to settle out of court to avoid further conflict? Basically, where the client is too scared to proceed to trial and prefers to appease the abuser. Jonathan or Jean, do you have any suggestions?
I'm going to want to put into the order as much protection as I possibly can. I'm certainly not going to abandon the victim. I would likely, I would not likely, I would possibly try and divert the case earlier to MedArb, but some people can't afford that. But I want protections in the order. I don't want to have my client running back to court every moment when something happens. And therefore, and also what one remedy I will try for frequently is a parental coordinator.
Mm-hmm. Yeah, that's a good suggestion. And, I think the court has a much broader range of options than we often are exposed to in these cases. For example, I learned this recently, like a family court judge can order a monitoring device on someone who's violent, which I thought was only possible in criminal court. But so I don't think we've really explored the range of options that are available under the law, and I think we need to get more serious about looking at what steps the court can do to, A, take the violence seriously, and B, prevent it from happening again.
Thanks so much, guys. That actually leads us really nicely into our next question, which is, do you have suggestions on how to educate a judge to understand family violence? Even with the case law and with Kira's law, there are judges who are very dismissive.
It's well established in Canadian case law that judges may consider social science articles. Now, very few people will have the wherewithal to bring an expert on family violence and explain it live to the judge. But it's easy to get social science articles. And in fact, as I mentioned earlier, I'm giving you guys some of the recent literature on it in the handout coming to you afterwards. Don't give the judge 30, 40 articles. Give the judge 2, 3, or 4 articles and highlight in yellow the most important portions that relate to the facts of your case. And in your opening and closing argument, make reference to the social science resources. Secondly, don't assume that the judge knows the law with respect to family violence. I've pieced together earlier in this webinar the statutory sections, and I went through it very, very quickly and only touched on some of the cases. Again, you can't bury the judge with 30 cases. He or she will not read them. But give 3, 4, or 5 of the best cases that relate to your fact situation and take the time to explain to the judge what the case law says, what the literature says, and why your proposed order, which all courts require you to file in advance, meets the needs of the children. Jonathan?
Yeah, I mean, I have a lot less direct experience working with judges, but when I'm testifying as an expert for a Section 30 assessment, I will often go into details about the theory behind why family violence is so bad for children. For example, I'll explain what ACEs are. I've been finding a steady and slow progress in what I've seen from judges in terms of their knowledge about family violence and their ability to manage it. It's slowly and steadily improving. It's not as fast as it should be, and there's still an enormous amount of work to do. But I have seen that newer judges tend to be much better educated on it and much more knowledgeable about it. I'm much more likely to see them at the AFCC conference, learning about the latest study that's been done on family violence, for example. So I think things are moving in the right direction. Yeah, it's hard for me to say how to educate a judge when I'm kind of standing outside the process and only kind of popping in if I'm asked to testify in a trial or hearing or something.
Well, that's the role of lawyers. That's what advocacy is all about.
Thank you, gentlemen, both. Okay, I see Daphne is ready to wrap us up.
Yes, thank you so much, Michelle.
And it's 1:14 p.m. and the webinar ends at 1:15 p.m. So congratulations to all of us for keeping to the schedule. And I'm
think,
sorry.
like, the list of questions that we didn't answer shows that this is a huge
Yes.
topic. A lot of people are really interested. Your questions have been phenomenal, like really, really top-notch questions.
Very
I've
good
found.
questions.
So, yeah.
Very good questions. Sorry we didn't get to them all.
Yeah.
Okay, thank you so much, Michelle, Jonathan, and Jean, for such an important presentation. And thank you to our audience for watching. I did want to mention as well that this program has been accredited by the LSO for 1 hour of professionalism content. So hopefully you find that helpful. And just thank you again so much, everyone, for your time, and enjoy the rest of your day.
Thank you.
Thank you, everyone. Take care.